As far as the constitutional issues were concerned, those were clearly set out before my lords, Article 14, 15, 19, 21, etc. The case law is also clear before my lords. There was then a question of interpretation of the statute. Now, there are various provisions of statutory interpretation in my lordship's arsenal, both the principle of updating construction as to how to read, reading up, reading down, and so on. The question which I understood falls from my lords is how far my lords will go in their interpretation of the statute. At the heart, there are certain provisions of the SMA. So we left out personal law in terms of the Hindu Marriage Act altogether. At the core, there were certain provisions of the SMA, Section 2, Section 4, Section 27, 36, 37, and so on, which were read by my learned friend, Dr. Singhvi. And there, the proposition that broadly has emerged is that my lords can read the words my lords can read the words husband and wife, bride, bridegroom, etc., insofar as they occur in the statute, either in a gender neutral manner or by reading in the word spouse. So the general proposition then is that there is an act of reading in, an act of expansion of the statute to include a hitherto excluded class, which both updates the statute in terms of present day reading and understanding of relationships, and secondly, brings it in tune with our current understanding of the Constitution. Now, my lord, the questions which fell from your lordships yesterday pertain to, firstly, Section 21A of the Special Marriage Act, which I've sought to address in this note I've now submitted. And the question that follows is, to what extent do my lords then retain personal law for LGBTQ couples who may marry under this statute, who may be similarly placed to other couples, that is, opposite sex Hindu couples, to which Section 21A applies? That is the first question which your lordships raised yesterday and which I believe is troubling your lordships. The second question is a more general question, that when we look at general civil statutes that relate to the rights, what we are so far calling the rights and obligations of marriage, to what extent will those apply to LGBTQ couples who marry under the Special Marriage Act? So we are confined, my lord, to the Special Marriage Act. But the question is, what are the consequences of the interpretation that would follow if your lordships were to decide in favor of the petitioners? Now, I will take my lords through my reasoning as set out here for both the first and the second question, but the conclusion I'll come to is this, that your lordships cannot decide every question today. The statutes, whether we talk of gratuity, as my lords did yesterday, pension, there are any number of benefits that and obligations that flow for married couples, or whether we speak of the consequences of 21A, these, my lords, are complex statutes, and LGBTQ couples, as it fell from my Lord Justice call on day one, LGBTQ couples will come to your lordships, and more importantly, in fact, to the courts below, to family courts, to civil courts, and to the high courts, with questions of statutory interpretations as they raise claims and they seek the protection of law in the same manner as opposite sex couples do and have done now, perhaps since the codification began of matrimonial laws starting from the early 1800s onwards. So we are no different in that regard. In fact, if I may say, what we ask for today is the right to not be different, that our differences stand ameliorated by our inclusion under this one statute. So what your lordships have said so far is that the application of the Special Marriage Act would be expanded, and then it would apply to us as it does to all other couples. That, my lord, is my submission, would continue to be the reading for 21A and for other general civil laws. And what I would submit, my lord, is that a declaration, both a positive declaration in the form of mandamus and a negative declaration in the form of prohibition, would go a long way in easing the work of the courts below in the interpretation of the statutes, as they must now commence doing in the work that they will have to come. If my lord will see, I have set out that declaration at the very beginning of the note. It is first, my lord, do my lords have it? In paragraph 3.
Yes.
My lords have it? Justice Kaul and Justice Bhat?
Yes.
I'm obliged. I'm obliged. So we seek, my lord, first the positive declaration that a marriage solemnized or registered, it would be solemnized, I apologize. Marriage solemnized under the SMA 54 and the parties to the said marriage shall be entitled to all the rights and obligations conferred on a married couple or a party to such marriage under any other state or central law, notwithstanding the gender identity and sexual orientation of the couple. And your lordships would also, I propose, give a negative declaration binding the state that the state nor any authority of the state shall deny rights and obligations conferred on a married couple or such party, and then the formulation is the same under the Special Marriage Act only on the grounds of sexual orientation or gender identity.
Yes.
With this groundwork in place, my lords, I'll now come to the first question which fell from your lordships yesterday. And my lords, let me say, it is not a light question. It is not a question to be easily decided. It is not a light question for us to consider either, to contemplate. As far as Section 21A is concerned, I would first submit that on a statutory reading, in terms of the application of the principles of statutory interpretation, which your lordships will consider, 21A will apply to same-sex or LGBTQ married couples who marry under the SMA in the same manner and with the same force as it would apply to an opposite-sex couple. Now, for my lord's convenience, I have actually set out the section in the note itself, but we can take it from the statute as your lordships prefer. May I read for your lordship's benefit? It's, my lord, at page 5 of my note. There's a table set out, but otherwise, if my lords have it, I'll just go ahead. Special provision in certain cases. Where the marriage is solemnized under this act of any person who professes the Hindu, Buddhist, Sikh or Jain religion with a person who professes the Hindu, Buddhist, Sikh or Jain religion, section 19 and 21 shall not apply, and so much of section 20 as creates a disability shall also not apply. Now, my lord, let's read the chapter starting from section 19. Section 19, my lords, the marriage solemnized under this act of any member of an undivided Hindu family, an undivided family who professes the Hindu, Buddhist, Sikh or Jaina religions shall be deemed to effect his severance from such family. And let me say, my lords, that the membership of such a family is not something which we take lightly. It is an important part, my lord, of the way in which we see ourselves as members of the family and as society. But, my lord, section 20, subject to the provisions of section 19, any person whose marriage is solemnized under this act shall have the same rights and shall be subject to the same disabilities in regard to the right of succession to any property as a person to whom the Caste Disabilities Removal Act 1850 applies. I'll take my lordship to the Caste Disabilities Removal Act also. Section 21, succession to properties married under properties of persons married under the Act. Notwithstanding any restrictions contained in the Indian Succession Act with respect of its application to members of certain communities, succession to the property of any person whose marriage is solemnized under this Act and to the property of the issue of such marriage shall be regulated by the provisions of the said Act, and for the purposes of this Act shall have effect as if Chapter 3 of Part 5, special rules for Parsi successions for interstate, had been removed therefrom. Now, my lords, what is the overall effect of this chapter? Firstly, upon marriage of a Hindu, Buddhist, Sikh or Jain to a person who, in light of section 21, is not a member of that faith, you are severed from the joint family. Secondly, my lord, these disabilities under this Caste Disabilities Removal Act, my lord, of 1850 is saved under section 20. Thirdly, my lords, I am removed from the operation of the Hindu Succession Act if I marry a non-Hindu, and now placed under the Indian Succession Act, as fell from my lords yesterday. But 21A, if we come back to it, it has the effect, firstly, of saying that 19 and 21 will not apply to me if I marry another Hindu. And secondly, it does not apply to non-Hindus, that is, persons of other religions who may marry within their faith. But 19 and 21 apply to those persons.
Ms. Katju.
My lord.
I think there is one caveat there.
My lord.
Whereas you are right on the first part, the second part will have to be seen loosely. because you're presupposing that there could be other two same-sex couples from the same religion.
My lord.
Have a Christian and a Muslim,
My lord.
Christian and a Parsi, or a Jew and a Muslim, or whatever. So
My
all
lord.
limitations are there,
My
which
lord.
means to that extent you will have to look into the provisions of the Succession Act, concerned provisions of the Succession Act start with, and other personal laws. Now that
Yes,
is
my lord.
one complication. And the second is, you are very right in straight away stating that the Hindu Succession Act will apply, or whatever laws of Hindus will apply to to uh, to same-sex couples who are both Hindus. But that means necessarily, willy-nilly, we will have to interpret. And there, like all of you keep repeating, life doesn't wait. So if there is an unforeseen circumstance like an accident in the absence of a will, or something else, then necessarily the spouse stands excluded. Either Section 8 or the rules of succession of females, or we don't know what other complications are there in other provisions.
And may I say, my lords, perhaps today we cannot know. And we must, I say this with all humility, having considered various aspects of this matter for many years, that all aspects of or questions which may arise before the courts are not clear to us today, as they are not in any case. Your lordships have time and again gone back to the institution of marriage as codified under various statutes and read in various nuances which arose with the passage of time. So, as fell from my Lord Justice call, these questions we will be here time and again. But as far as this question which my Lord Justice Bhat raised, yes, there will be couples who are LGBTQ and, my lords, who are interfaith couples. And there, my lord, 21A will apply to them as an interfaith couple. And
I'll
there
just
will be couples, my lord, who are Hindu and LGBTQ. And there, my lords, 21A will apply to them as a Hindu couple. Your lordships are not required today to further read the act beyond reading in and explicating the word spouse,
we look
or,
at,
my lords, my lord,
yes, Miss Katju,
my lord,
then jurisprudence of this court, which has dealt with provisions of law and their constitutionality, has never isolated one provision. You
my
take
lord,
it to minorities in the field of education. When an enactment is there, the organic whole has to be seen in the context of a challenge to the concerned provision.
my
Whether
lord,
World Control Act, which was seen in the 60s, or even Frank Anthony, which examined the entire provisions of the Delhi Education Act to see the impact on one section. So there is an organic whole. So to isolate one would not be in consonance with this the approach of this court. That would be leaving things half done, mostly undone. Therefore, how this has to apply will have to be ultimately taken on by us at one go. That's one way of looking at it.
my lord.
Your of you have been consistent saying that these are battles which will be fought later. But that does it absolve us of the duty of constitutional the obligation of seeing and considering doctrinally the impact of one provision over the other, or many provisions over one? That you will that we will have to keep in mind.
My
Your
lords,
All of you have given one picture, that
my
I'll
lords,
the rest, look at only this, and this is what we want.
may I submit?
Actually articulated the positive and the negative part. So I think it, in a way, summarizes the entire, let's say, project.
May I say, my lords, that my lord may be right. As a matter of constitutional explication, the constitutional underpinnings must be taken through to their logical end. But, my lord, as far as one provision or the other is concerned, I may say that in my own reading of and research into 21A, aside from one judgment before the Honorable Delhi High Court in 84, we did not find any other challenges, my lord, to the constitutionality or otherwise of 21A. I would submit that it poses no problem because it is a part of the seamless whole of the statute as it stands today in light of the legislative developments that have taken place since 1850.